Still can't see. Still can't. Well, I'm fine. I just need my coffee. Eat. Stay. You give me. Can I have some more coffee? What are you eating already?
Good morning, everybody.
Morning, Jeff.
So Kit, who do we have on site?
Just Mark.
Not just Mark. All right.
I don't see Ed online yet, but I think everybody else, Julie and Tom, are on Zoom, I believe.
Did Ed say he was joining us? Good morning.
He did say he was going to join on Zoom.
I don't see Julie anymore.
Uh-oh. Did we lose Julie?
Yeah, I don't either. I don't see Julie.
She was here.
She was.
Well, hopefully she will come back.
Well, I'll wait a minute for her at least to join us. I don't really mind starting at least the first part of the meeting without Ed. If he's going to join us late, but Julie was here a second ago, so.
Yeah, she just came back.
Okay, great. Otherwise, we ready?
So,
Okay. Well, with all due respect to Ed, we'll start without him and hopefully he'll jump in. Good morning, I'm Jeff Ashby, and on behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device to ensure that those devices are silenced now, or keep yourself on mute if you're attending via Zoom. We have additional agendas, including the consent agenda available. We've provided them electronically, and then they're available on site in Augusta in the room there. We have the consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted period. The commission has voted on those cases, and they will not be considered further today. And I'm going to dig up my agenda here, so bear with me.
have Ed now too.
Oh, perfect.
Morning.
Morning.
Well, let's start. Good morning, Ed. Let's start then by adopting the consent agenda.
Oh, not sure. There we go.
All right, our remote participation policy requires me to make sure that commissioners' votes can be both seen and heard. So I'll be polling the commissioners who will need to signify their vote both orally and visually. We have a motion to adopt the agenda and consent agenda.
So moved.
Okay.
Second.
Moved and seconded. Any discussion? Seeing none, if you vote yes, you're in agreement. Chelsea, can you pin Tom, please? Okay, Commissioner Ashby.
I'm going to abstain.
Commissioner David.
Yes.
Commissioner O'Brien.
Can you hear me?
I can.
But you can't see me, right?
Can't see you.
No, I don't know what's going on. I just
right.
lost all power for a minute.
Us too.
Oh, okay.
Yeah. So.
Well, I'm saying yes, but so that's
Okay.
half yes.
We'll take it. It's what we've got right now. Commissioner
Okay.
Douglas. Great. And Commissioner Walker.
Yes.
Okay. Commissioner Douglas, you are muted.
Thank you.
Next, I'll entertain a motion to adopt the minutes of the November 2023 commission meeting.
So moved.
Second.
Moved and seconded. Any discussion?
Yes, there's a typo. Geez, I don't have them right in front of me. It's not essential.
Do you know where
What are we
it was?
doing? We're doing the minutes.
Yes.
It was the E21 case. And it's, as I say, it's just a typo.
Shapiro or Nguyen?
Not sure. I'll
Okay.
come back and give it to you. It's just the insertion of a word and that the, but I'll find it. Never mind.
Okay. All right. So it's been moved and seconded. We've decided that typo is not critical.
No.
Okay. So if you vote yes, you're in agreement. Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Douglas,
Yes.
Commissioner Walker.
Yes.
Okay.
Excellent. And now Kit, the director's report.
Yes, so you have a memorandum from me as to personnel, which is that we have had no developments in personnel, though I suspect that will change come January. Compliant, okay. You have a memo from Jane about conciliation. We have, I believe, I counted this, 10 cases currently in conciliation. So everybody send Jane some coffee. We have no unsuccessful conciliations and no successful conciliations. And for new charges, we have had 34 new charges in.
Yeah, we
I'm
have a
sorry.
question. I'm sorry, we have a
Yes,
question from
yeah.
Ed.
Yeah, Kit, in the conciliation report, what does the 90 days indicate? Is that when you have to schedule within or?
Yes, so the 90 under active conciliation, the 90 days is the 90 days that we have to schedule conciliation.
You mean they have been scheduled? There's just so many that are waiting for over 3
Yeah.
different months that I wondered what was going on.
Yeah, so those are the first case I think was on the, oh, maybe the August or September agenda, I forget. So that case will, it looks like we're still waiting on a response from both parties. That case will fail conciliation on December 17th because nothing has been scheduled.
That's the answer to my question. That date is the failure date if it doesn't get responded and scheduled.
Exactly. Yeah.
Thank
so
you.
these are the 10 cases that are still within their 90 days. Some
Thank
of them
you.
have been scheduled and some of them we don't have a response yet.
Thank you.
Yes. All right. And for new charges, we have had 34 new charges. I apologize. This report says in September. This is actually for November 1st through 30th. 15 dismissals. Again, you can see 10 active conciliation. We've had 4 cases that have withdrawn with benefits. I apologize again. I don't have the numbers in front of me, but I can certainly let you know by email for how much money went to complainants in those cases.
Again, a quick question, just so I'm beginning to understand after 4 years here. The 34 is the total number filed, and then the administrative dismissals of 15 bring it down to 19 new cases that are actually being assigned for investigation and process?
No, so we've had 34 new complaints filed in November. And of the total number of pending cases at the commission, I've either dismissed or people have requested right to sues or people have settled or withdrawn their cases in 15 of the cases total pending here right now. So those 15 are not part of the 34.
Okay, does the report give us a number that are in process, a total number that are being processed?
Can you hear me, Ed?
Yes, I can hear you now. Video's not back on yet, but
The power just flickered here.
yeah, we can hear you. Except you're on mute now.
It's on.
Yeah, the power is flickering here, so we'll see how this goes.
Didn't mean to ask a difficult question, Kit.
No, it's not a difficult question. The report does not include that number. I can get it to you, but I don't have it off the top of my head.
No problem. No problem. Don't stop to do it. I'm just trying to
It's
understand.
usually between 600 and 700.
The TV equipment's not.
We're having some difficulties with our camera. I'm going to turn mine on. There. All right. Can you see me?
Yep.
Do you want me to mute that? And
No.
Okay.
Yeah, the camera's right on you instead of the table, but that's fine.
Oh, there we go.
There you go. Good.
For the moment. All right. So I don't have, I'll ask that we take litigation in executive session. I have no new business right now.
Okay, great, thank you. Well, let's take 5 minutes.
Did you just lose it again?
Yeah, I think so, Julie. This is Ed.
Hi,
Oh, no,
Yeah.
Kits, no, they're on. They're on. The videos are on. Both of them. Kit's on and
okay,
the table with Mark.
yep, okay, yep.
All right. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium or recognized on Zoom to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. The procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions, and I'll ask that you would introduce yourself as you are recognized or come to the podium. Thank you. The first case on the agenda today is E22-0004. That's Tina Burgoyne versus St. Croix Regional Family Health Center. That is a reasonable grounds case, and as a result, we should hear from the respondents or its representative.
Morning, my name is Rick Finberg and I represent respondent St. Croix Family Regional Medical Practice. As our written submissions indicate, or submission indicates, we do object to the investigator's finding, asking a recommendation, asking the commission to find reasonable grounds. We think the documented evidence supports a finding of no reasonable grounds. It's important to note that in this matter, the report was based solely on the written submissions. And the investigator acknowledges, I think, in his initial part of the report, the limitations of rendering an opinion based solely on written submissions, and indicates that the investigation is merely a preliminary investigation, and that highlights the limitations when witnesses are not interviewed and there is not an opportunity to drill down with regard to factual disputes that can be layered and in some respects a bit convoluted in this case. What I will note initially in terms of the background, which you all have before you, is that the nonprofit Family Health Center engaged Dr. Burgoyne to serve as an interim dentist in March of 2020. They entered into a written employment agreement that noted that this interim assignment was on an at-will basis. But if the regional health center opted to terminate without cause, it agreed to provide Dr. Burgoyne with 30 days written notice. And if it chose to take the route of with cause, it had the ability to terminate without any notice. The record evidence indicates throughout their 1-year relationship that there were rocky times in terms of personal interactions with Dr. Burgoyne's staff and scheduling challenges due to work-life balance and conflicts with childcare arrangements. Those were the focus of the back and forth. In addition, a primary issue was the backlog of progress notes that Dr. Burgoyne was required to complete for each of the patient services delivered. The policy provides that the progress note should be completed within 7 days of providing the service. At the time notice of termination was provided, Dr. Burgoyne had over 100 open progress notes dating back to April. The record evidence, the written evidence, which is all we have to go by here because there were no credibility assessments really made, is that when Dr. Burgoyne raised any issues throughout the 1-year process in terms of recommendations for better practices, the management team always responded in a positive manner. And we submitted those documented responses to Dr. Burgoyne's suggestions, in which the executive director, without exception, always thanked her for her suggestions and typically accepted the recommendations with an exclamation point that the executive director appreciated Dr. Burgoyne's input. Nowhere in the record, from start to end, is there any evidence to suggest that the health center ever took a negative response or made a negative response in terms of any suggestions or issues that Dr. Burgoyne raised. The recommendation that you find reasonable grounds that retaliation took place is based on nothing more than a hunch. There is nothing in the record to suggest that there was any type of animus. In June of 2021, there are virtual contemporaneous notes from management after meeting with Dr. Burgoyne near the end of her tenure. And the notes taken shortly after the meeting indicate from management, Dr. Burgoyne reported that she was pursuing a private career before she took this position. I feel she may be regretting not continuing that path, and it may be contributing to her dissatisfaction. Her demeanor yesterday reeked of irritation, resentment, and annoyance. I do not believe she will continue with the organization, and we need to focus on an exit strategy for her at this point. Hopefully, she can complete the charting before she ends her employment. There's nothing in these notes to suggest there was any negative feelings because of any issues raised during the 1-year employment tenure. Towards the end of June of 2021, Dr. Burgoyne needed to take 2 weeks off due to the loss of childcare. She did blame the health center for her loss of childcare due to scheduling issues and running late in terms of picking up her kids at the end of the day, and demanded as part of her unhappiness with the health center that the health center pay her full salary without drawing on PTO for her 2-week absence. When she returned from that 2-week leave in early July, management met again on July 7th, 2021, and they talked about the open progress notes, and they also talked about Dr. Burgoyne's repeated suggestion that she was going to resign. In fact, when she took on the assignment of interim dentist, she noted to them that her intention was to open a private practice within 6 to 24 months, that they would do well to continue to recruit for a more long-term dentist, but she was happy to help in the short term. That was always the understanding between the parties, that this was a short-term assignment. At the July 7th meeting, they talked again because Dr. Burgoyne wanted a transition plan for when she did submit her resignation. On July 8th, the day after this meeting, she sent a missive to the management team that she expected by the end of the day a plan from the health agency for how they were going to transition the patients when she did submit her resignation. All of that points to the likelihood that it was reasonable for all the parties to assume that this relationship was coming to an end and that they needed to make plans. Based on that, the notes from the July 7th meeting and the June meeting indicate that the focus was on Dr. Burgoyne's repeated threats to resign and the need to move on, her unhappiness with the work-life balance and her schedule. And based on that, this nonprofit opted to provide her with 30 days notice, not because they didn't think there were issues with regard to the relationship, but as we can all appreciate, because terminating without cause is a less adversarial approach to parting ways. And they wanted to give her with the 30 days notice. And so that's what they did. The investigator, with my remaining time, I'll highlight, relies on a handful of reasons why he has a hunch that retaliation likely took place. One, he says that the health agency provided contradictory reasons for the termination because now, as part of this response, we raise issues with her interactions with others and the problems with the progress notes, et cetera, and claims this is in conflict with terminating someone without cause. This is not in conflict. It makes sense to take the path easier traveled, and that's the only reason she was terminated without cause. The investigator also relies on two personal references, one written by her mother-in-law and the other by the individual who helped the health agency recruit her because she's a good friend of hers and had practiced with her at another practice. These two folks did not have any personal knowledge as to the reasons for the separation, and the investigator didn't have the opportunity to interview any other employees. So the reliance on self-serving personal references is misplaced. The investigator was dismissive of the health center's evidence in terms of the open progress notes and how important that was to getting paid and having best practices for good medical records. And finally, the whistleblower piece. The investigator relies on the fact that Dr. Burgoyne raised issues from time to time without having any ability to cite to why he thinks the health center reacted negatively, because there's no evidence that the health center ever did. There is an issue as to whether these or the last issue raised in terms of potential upcoding by predecessor dentists, whether that was done in good faith, and the investigator never analyzes the good faith issue, which is a requirement for meeting the prima facie case of a whistleblower case under the Whistleblower Protection Act. So for all those reasons, I think in the submissions, there is clear evidence that the health agency separated for one reason and one reason only. Dr. Burgoyne was clearly unhappy. She threatened to resign multiple times. She didn't like the work-life balance. And they had over 100 open progress notes that they needed to address. And so it made sense for them to part ways and do so in an amicable basis. And that's what they did. I asked the commission to reject the investigator's report and vote finding there are no reasonable grounds. Thank you.
All right, thank you, Attorney Finberg. Any questions for Respondents' Counsel?
I had a question.
All right, yeah, Commissioner Ashby and then Commissioner David.
Good morning, Attorney Feinberg.
Good morning.
So the one fact that the investigator focused on that you didn't address in your submission just now is this receptionist employee who it was alleged by you folks that the complainant in this case was abusive or somehow didn't get along with staff. And some specific reference was made apparently by you in the course of the investigation of the case to a date where the complainant was alleged to have talked to a receptionist in a way that was abusive or made the receptionist upset. And as I understand it, the complainants counsel presented in the course of the case something from that very day from this same receptionist who seemed to be very friendly, on very friendly terms with the complainant. I think that's how I understand the evidence. First of all, do you understand the evidence to be that? And then secondly, if so, can you address that? Because I think the investigator hung his hat on his, right? Who did the call into it? Hung his hat on that when he had to address the pretextual argument when addressing your reasons for terminating the complainant.
Yeah, that's not exactly the first part of your question. That is my understanding. I will note, just for context, that I was not the original attorney in this matter and didn't put together the submissions. So my familiarity might not be as detailed as it typically is. But my understanding is that there were issues with more than one employee, including the receptionist. The executive director observed some of those rude behaviors. And what the investigator, my recollection is, relied on is that in the original submission, there was an incorrect date as to when one of the interactions took place in November, I believe, of 2020. And I would submit that a mistaken day in a month shouldn't be relied on as the end all for assessing credibility in terms of the written submissions rather than meeting with the witnesses. I don't recall, that the relationships with the employees were inconsistent and intermittently had friction between the employees and Dr. Burgoyne. We never took any issues with the skill set. So I think had there been an opportunity for a robust investigation where witnesses were interviewed, the investigator would have learned that there was friction, including with the mother-in-law who submitted an after-the-fact personal reference to support her daughter-in-law, Dr. Burgoyne. That employees were occasionally brought to tears, and I think a more robust investigation would have shown that.
Thank you.
Commissioner David.
Yes, good morning, Attorney Feinberg. What is the significance of reducing her hours to 30 hours in June? We're just a month before the separation.
No, yes, good morning, Commissioner. There were several actually adjustments to the schedule. They were all done in coordination with Dr. Burgoyne. The initial adjustment was to provide her with additional time for administrative work. And so they carved out 8 hours for her to do administrative work. And they made various adjustments throughout her one-year tenure to try to find the sweet spot that would work to allow her time to complete progress notes and provide the clinical services. They tried carving out an hour at the end of the day for a period of time. And my understanding is with the adjustment from 32 to 30, that was a minor adjustment to account for other benefits. And there wasn't a lot of focus during the investigation or during the employment in terms of any complaints about adjustments to hours. That wasn't the source of why the relationship broke apart. But I think even Dr. Burgoyne would acknowledge throughout the one-year period that she wasn't satisfied with the work-life balance. She didn't think the schedule was working out well, and she didn't think the scheduling allowed her an opportunity to leave work on a timely basis to pick up her kids. So there were those types of frictions throughout the one-year period, and I think the parties were trying to find something that might work for all. In the end, that didn't prove to be successful.
So you would reject the assertion, if it's made by the complainant, that reduction in hours is an attempt to push her further away to resigning?
Absolutely, yes. We absolutely reject that.
All right.
She was hired as an interim dentist, and throughout her one-year period, continually raised the prospect of resigning and was transparent, to her credit, that she wanted to open her own practice and viewed her tenure there as short-lived. And
Let me thank you. There's the two facts that I marked in my reading of this that I found to be very significant in terms of a whistleblower allegation that I don't believe that you addressed. One is that statements were taken out of minutes of a meeting. I'm a little bit vague on in my notes finding that back in the report, but the allegation was that minutes were removed that reflected a particular complaint or a particular situation. And the other, I'll ask you both these questions at the same time. The second appears to me to be even more significant, and that is that she refused to sign a statement that she was unaware of violations. And that seems to go directly to the heart of the matter, and you have not addressed that. Is that accurate, that she's asked to make such a statement and she says, no, I know there's, she's effectively saying, no, I know there's violations, I'm not signing that?
There is a dispute of fact on that issue. And with regard to the initial part of your question, I'm not aware of any minutes being reviewed. I know the investigator relied on actual notes taken by management. He read them to, he placed reliance on certain statements in those notes in a way that I would not have. And the second part of your question again, I'm sorry, Commissioner, was?
She refused to sign the statement that she's
Thank you.
unaware
Yes.
of violations.
Yes, thank you. So yes, there was a request to ask employees to re-sign policies, and the notes indicate that she declined. It was not their understanding that she was declining because she thought that there were outstanding safety or other issues that were a problem. The record is without dispute that when she did raise issues, the executive director responded in emails thanking her and in a positive way with an exclamation point, appreciating what she brought to the table. The investigator was completely dismissive of those entries.
You're saying that there are notes specifically addressing the fact that she did not refuse to sign the statement?
No, there are notes of the June meeting and the July 7th meeting in which there's a running, it's basically hand scratches in terms of listing out what they talked about. I don't recall if the policy issue was specifically discussed at one of those meetings. I don't want to misspeak, but they do dispute that they were under any impression that she was refusing to sign policies because she thought there were unresolved issues. We reject that.
All right. And the very last thing, which I think is a straightforward question, she completed all of those notes, those 100-odd notes before she left, did she not?
She completed them. They gave her the 30-day notice, and during that period, she didn't perform any clinical services. So her only task during the final 30 days were to complete those progress notes. That's all she needed to do. And yes, my understanding is that during that 30-day period where she was performing no clinical services, she did complete those progress notes.
Thank you.
Any other commissioner questions for Attorney Finberg? Seeing none, you used all your time, so move to Attorney Beard. You have 10 minutes, Attorney Beard, whenever you're ready.
Thank you. And yeah, just before I begin, as a procedural point, there would be no point in me reserving time, correct? There will be no further questioning by Attorney Finberg. Okay, thank you. Okay, good morning, commissioners. I'm Braden Beard. I'm representing the complainant, Dr. Bourgoin. Dr. Bourgoin worked for St. Croix for a little over a year. She began, before she started, there were some communications about it being a temporary position, but she quickly became the director of the dental department and became in a much more permanent long-term role. And in her role as the dental director, she tried to make improvements to the dental department, and she made a number of reports, which included raising safety concerns, raising fraudulent billing, deceptive government reporting, and unethical and substandard patient care practices. And while the administration was initially receptive, I think, to maybe 2 of the complaints she raised, their attitude quickly soured and became hostile, ultimately leading to her demotion in March of 2021. She was removed as the dental director and then terminated in July of 2021. So there's a couple of sort of refrains that respondent makes here that I think we can dispense with quickly. And the first is that Dr. Bourgoin's employment was always intended to be temporary. It's simply not true. The communications they reference are from before Dr. Bourgoin even started. Within a few months of her being there, she had become the dental director. Her role was expanded. She was very committed to working to improve the dental department. And she and the administration had multiple conversations about her staying on long term. Second, these arguments about the investigator only finding the way he did because he didn't interview witnesses, he didn't have more of an investigation. This phrase, preliminary investigation, as far as I can tell, that's in the opening paragraph of every investigator's report, regardless of whether they had a fact finding or an IRC. And during the investigation, respondent could have raised a concern about there not being an IRC or fact finding, and they didn't. They also could have submitted witness statements or affidavits before the close of evidence, particularly because the most recent thing in the record was complainant's detailed reply, which attached numerous exhibits. They had a chance to rebut those points, and they chose not to. And that sort of goes hand in hand here with respondent simply hasn't offered evidence to support its arguments. It blames the investigator, but again, it could have put things in the record and it didn't. Dr. Bourgoin, on the other hand, submitted proof that some of respondent's arguments are simply false. As Commissioner Ashby pointed out, they accuse her of berating an employee on a certain date, and respondent proved that that is false. And now respondent simply tries to say, well, I guess it was on some different day. But again, they provide no evidence of that either. More generally, they provide no evidence that other employees complained about Dr. Bourgoin. They have no evidence of that. So again, going back to the close of evidence, rather than submit witness statements, the respondent submitted nothing. Complainant pointed out in her close of evidence submission that numerous employees that respondent presumably claims would have supported its position had left St. Croix soon after Dr. Bourgoin was terminated, which I think leads to a reasonable inference here that they did not view St. Croix favorably. And if they had been engaged by the investigator, their statements likely would have supported the complainant, not the respondent. Respondent claims that Dr. Bourgoin didn't engage in good faith about safety and compliance problems, but again, points to no examples or evidence of that. To the contrary, Dr. Bourgoin raised numerous good faith reports. She raised complaints about fraud. The objection claims Dr. Bourgoin never provided examples of these, but Dr. Bourgoin not only explained them while she worked there, we provided examples in our MHRC reply. A specific case of charging for a more expensive dental implant than what was given to the patient. Dr. Bourgoin talked to multiple levels of management about this, starting with the executive director who brushed her off. She tried to follow the process that was in place under the employee manual, which she was encouraged to do by the operations director. Again, another senior employee who resigned actually soon before Dr. Bourgoin was fired. No one would give her a grievance form to complete that process. They clearly were not receptive to her complaints and reports of fraud. Very notably, the objection makes no mention of Dr. Burgoyne's clear complaints that St. Croix had instructed employees to alter patient blood pressure readings to ultimately increase their federal funding. This is the issue that was in the draft meeting minutes that Commissioner David pointed out that was then removed from the final minutes after Dr. Burgoyne had raised that concern in a meeting. Also, going to the commissioner's questions, the record is clear that Dr. Burgoyne refused to sign a statement saying that she wasn't aware of violations of law because she was aware of those violations and she was raising reports of them. She told the administration that. There's a note on the document saying that she chose not to sign it for reasons that she explained to the administration. Again, those reasons are her concerns about legal violations. Respondent falsely states that the administration always responded positively to Dr. Burgoyne's reports of legal violations. It's clearly not true. There are two concerns that she raised early that the executive director responded positively to. Those were in, I think, August and September of 2020. As Dr. Burgoyne continued to raise concerns, the executive director would either ignore them or ultimately demoted her from being the dental director a few months later. Also, in terms of those responses, while the executive director makes that statement in an email about, good job, we're going to order those OSHA manuals, she never actually did that. Some other safety complaints, there was blood-soaked gauze that was found just to clarify the record, it was found in a normal trash can, not in a dumpster. We submitted the complaint form that Dr. Burgoyne submitted. It clearly states that it was a normal trash can. And Dr. Burgoyne raised a lot of serious concerns about violations of the standard of care, which again is another subsection in Maine Whistleblowers Protection Act. There's also ample evidence of causation. Temporal evidence is very strong here. We've submitted evidence that she was told directly by the finance director and the executive director not to raise complaints, not to complain about things. There's a lot of evidence here of pretext. I've already touched on several of these, but the respondent continues to make simply false statements about Dr. Burgoyne, including this complaints by other employees in November 2020, and no evidence of those. We countered the evidence that they tried to offer. They have repeated a fabricated interaction between Dr. Burgoyne and the executive director from late 2020. Again, no evidence of this. It would have been in her personnel file if these kind of serious things had happened. Reducing Dr. Burgoyne's hours in June 2021 was certainly part of the pattern of retaliation. We alleged that in our complaint. I am going to quickly move to my objection. It's a somewhat technical argument, but put simply, I'm not aware of any other statutes that aren't affected by procedural rules and statutes that shift a weekend deadline to the next business day. So under Maine statutes, procedural rules, and the MHRC's rules, the 300th day should move to the next business day. And I lay that out in the objection. It's really more of a technical legal point. Sorry, last point I will address the, providing her notice and calling it a termination without cause. It's simply not credible that St. Croix would voluntarily give her 30 days of pay when it didn't have to.
That's your time.
Okay.
Commissioner questions for Attorney Beard? Yes, Commissioner Ashby.
Thank you. I have a couple of questions. One is hopefully easy and quick, and the other probably will be a little weedier. I'm sorry. The first relates to your last argument about the timeline. Is it only a technical issue that you're raising for our to bring to our attention, or is there a substantive significance to the 301 days? Because I understand that it's still a retaliation claim. The investigator found retaliation, and whether or not we consider the March 2021 demotion, it might be relevant to that claim, but it isn't a new claim, right? You're not making a separate claim.
Right, and I think the way that the investigator framed the ultimate finding is correct. I'm simply taking issue with the idea that the March 15th demotion couldn't be sort of independently actionable. That is an independent adverse employment action that we could file a complaint over. I assert that we did, in addition to separate adverse employment actions. I think, again, and even if the commission decides not to shift that 300-day deadline to the next business day, the demotion is still part of a kind of retaliatory storyline here. It's still something that should be considered by the commission, even if it's not considered as kind of an independent claim. There's the demotion and kind of a pattern of retaliation ultimately culminating in the termination.
Okay, right. I thought as much. I just wanted to make sure that that I was understanding it the way you did. The second question I have relates to this issue of what do we do in a retaliation case where the basis for termination is claimed by the respondent to be simply a termination at will, or not for cause. In this case, as I understand it, there's a claim, of course, of temporal proximity to the adverse action, and that included this termination sort of at will for not for cause. And then the way the analysis requires us to look at these cases, the respondent sort of must respond to explain the basis for termination, and it sort of puts the respondent in a position where I guess what I want to ask is this: the investigator found that it's evidence of pretext because the respondent claimed at one time they were terminating this employee without cause, but then when called upon to explain it and gave a reason, good or bad, the investigator said, aha, you're lying because you said that you terminated this person without cause. Now, none of that actually happened. I'm paraphrasing, but do you see how that's problematic in a case where if the only evidence of discrimination is temporal proximity, and the employer says, I terminated without cause, this person was very unhappy, well, even that's cause, I terminated without cause, it wasn't working out, whatever. It kind of puts the respondent in this position where there's it's sort of a lose-lose, right? They sort of can't win. Am I understanding that correctly?
I don't think it would be that straightforward. I mean, I think there's a few ways to look at this, right? So first, before we even get to pretext, the employer has to offer a legitimate non-retaliatory reason for the termination, right? Which, maybe just stating it was without cause, they can't state we have no reason. Let
me stop you right there, because I think you put your finger on it way better than I did and much quicker. What if the employer said at that point, because you made a statement that assumes a fact that I'm not sure is true, and that is that the employer has to give a reason for the termination or for the adverse action. What if the employer said, I'm just not going to tell you? What if our investigation was such that the employer responded and said, I gave a termination without cause. It's all I got to say about that. Wouldn't you really be stuck with only a discussion of temporal proximity and that's it?
I think that would be the end of the inquiry. If plaintiff makes a prima facie case and the burden shifts to the employer to provide a legitimate non-retaliatory reason, they have to do so. If they fail to do so, liability lies,
I see that. I mean, that's sort of what I'm wrestling with, but I think you're right. I just, and of course, in this case, the employer did give a reason. They met that, or they attempted to meet that burden. But
I think just to get into it a little more, I think there is a reason for that, right? That if an employer can offer no reason and a plaintiff has stated their prima facie case, which provides at least some evidence of retaliation, and the employer can't rebut that at all, it does make sense that we would apply an inference of retaliation. If the employer has no justification and the employee has made out their prima facie case, I don't think there's anything kind of unfair then about holding the employer liable. And that is the McDonnell-Douglas burden shifting framework.
Yeah, I guess I'm wrestling with the, excuse me, my phones are ringing off the hook. I apologize. I guess that's I'm just wrestling with that finding by the investigator that's, and again, I'm paraphrasing. It says, hey, you terminated without cause, but when we asked you what the reason was, you gave a reason, and therefore that's inherently contradictory, and as a result, that's a basis to find against you in this case. And I just think, I find that challenging, but I understand you. I guess you're right. The burden shifting framework does require the response by the employer, and then of course in this case this is an academic exercise, because in this case the employer did in fact respond. So, well, and just in terms of this specific point that you're raising by the investigator, I think that may be one piece of evidence. A shifting story like that is evidence of pretext. There is case law on that. I think it certainly isn't the only evidence in this case. And again, there is case law saying temporal proximity, when it's very close, it is significant evidence of causation. Here, it's not all we rely on, and it's not all the investigator relied on. There's a lot of factual evidence of the administration being upset with Dr. Bourgoin for raising her concerns and her whistleblower complaints. All right. Well, thank you for indulging me. I apologize for dragging that out.
No problem.
Commissioner David.
Thank you. Thank you. Attorney Beard, what's the date of that refusal to sign the statement that she's unaware of violations? Is that right next to just before the termination?
That one is not just before the termination. There is an email just before the termination where Dr. Bourgoin states very explicitly what you're doing is unethical and illegal. The refusal to sign is, I believe, in April 2021. So a couple of months before the termination.
And that email is when?
The email is in late June.
And says what?
I can try to pull it up. I believe it's in the record. But I know among the things it says is that some of the things that the administration were doing were unethical and illegal. And I believe that related specifically to canceling patients in the middle of their care, essentially, discharging patients who still needed help from the center.
There's some allegation about her leaving a patient, quote, in the chair, unquote. What is that about?
Yeah. So a couple aspects to that. By that point in time, Dr. Bourgoin had been removed as the dental director. She did not have control over how the department was run. And unfortunately, she did not have control over her scheduling. So a patient was scheduled at the end of the day for a very significant procedure, a procedure that ultimately made it so she could not pick up her kids in time, and she lost her childcare for a period of time. She completed part of a procedure and stopped at a medically sensible place to stop. It was a multiple-hour procedure that involved doing work on the upper teeth and lower teeth. She completed one level and then essentially closed and left the dental hygienist to. kind
Okay,
of do
that's my question. I've had a lot of dental work. Your assertion is that she completed, so that she stopped at a medically appropriate place and caused the patient, other than having to come back, medically nothing wrong with picking up the second half of the procedure on another day. Is that your assertion?
Yes, absolutely.
Okay.
And even as defendant or respondent says, they had no complaints about Dr. Burgoyne's skill and medical, efficacy. She would never leave a patient in the middle of a procedure in any way that would, be precarious or harmful to the patient.
Speaking of skill and efficacy, sort of in the background here, and again, hasn't been addressed yet, is this allegation that she is very substantially less productive than expected, which one can think the employer might not want to, bring to the forefront, but is simmering in the background of their desire to get rid of her. Can you address that? Her productivity?
Yeah, I mean, for one thing, they never said that was the reason they terminated her. So I don't know that.
Okay. All right.
Credit them with that. But more significantly, her predecessors that the employer pulls out their numbers and compares to were pre-COVID. Dr. Burgoyne worked, through the beginning of COVID, and still, spring of 2021. The objection tries to pretend like, oh, by then COVID wasn't a big deal. That's not true. It was still very much a state of emergency in the spring of 2021. Right. So, there were a lot of procedures that they had to follow between patients because of COVID. And we also, explain in the record that Dr. Burgoyne was performing some more substantial medical or dental procedures that her predecessors were not capable of doing. And those required more time. They required longer procedures and longer appointment times. So she was not seeing as many patients for those reasons.
Thank you.
Any other commissioner questions for Attorney Beard? Okay, seeing none. We've heard from both counsel. We'll now hear from Investigator Hurd.
Good morning, commissioners. First off, I just want to apologize if my voice sounds a little funny. I'm getting over a bout of COVID, so please forgive me if I sound a little different than usual. So first, to address the elephant in the room, I guess, no, I did not hold a conference in this case. The record was quite extensive, however. Respondents submitted over 100 pages of records and emails and whatnot, and then complainant also submitted several exhibits in their response. And there isn't much in the record that didn't also make it into the facts section in the investigator's report. As you saw in the report, the finding really came down to issues of pretext that I identified in the submissions. I'm not sure. So Commissioner Ashby is listening to, obviously your conversation with Attorney Beard, and I don't think that it's necessarily as simple as the way you phrased it, as that it's without cause and therefore, and you gave a cause, therefore pretext. I think really the issue for me was that there seemed to be multiple issues brought up, multiple explanations that weren't entirely consistent with one another, or that didn't fit with what was in the record. So respondent referred often to complainant's poor performance, her poor interoffice relationships. But, regarding the relationships, the evidence submitted went back to, I think, 2019 and sort of ended there, and then was contradicted by complainant's evidence submitted later. The performance issues, I guess, didn't take into context things like the environment. This is during the COVID pandemic and stuff like that. So it seemed, and I think these are laid out more explicitly in the report under section 6 of the analysis. Those were the 4 main issues really that stuck out to me when I was reading through these submissions. The last thing I wanted to address was the information that respondent brought up about the references about one being, I think, a mother and mother-in-law or something like that. That information was actually not made known to me during the investigation. And yes, I agree that may have come out in an interview, but I think it also could have been provided to me at any time. There was ample opportunity for both parties to submit evidence to me to respond to each other. And if respondent had submitted a statement, witness statement, signed witness statement of its own, obviously that would have been compelling, and maybe a conference would have been more appropriate. But given the submissions that I had, it seemed like I had sufficient evidence to make a determination, so I did. And then finally, regarding the complainant's procedural objection that they referenced, I'm going to defer all questions about that to commission counsel. And that's all I have. I'm happy to answer any questions that you have.
Commissioner Douglas, did you have your hand up?
I didn't yet. I was actually about to. So I don't know if you're psychic this morning.
Maybe I'm psychic this morning.
You read my mind. Good morning, Colin. I just wanted to, for the benefit of everyone, just try to sort of sum up what it is you've done here in your report, right? So as I read the report, basically on the issue of pretext, right? You're evaluating the evidence, and what I think you just said is that you found the complainant's sort of account of things in terms of why she was discharged to be more consistent than the respondents. Is that fair?
Yes.
Okay, thank you. I feel like that needed to be, seems like a very simple point, but I felt like that needed to be made clear. Can we engage commission counsel on the question of the procedural, the business day versus the weekend deadline?
Let me first see if there are any other commissioner questions for Colin, and then we can move to the procedural thing. Any other commissioner questions for Investigator Bird? Seeing none, thank you, Colin. Go get some rest.
Go back to bed.
All right.
I'll stay for the final vote.
That's dedication. What can I do for you, Commissioner Douglas?
I just wanted to get your take on this procedural question. Where do you come out on the Sunday versus business day deadline? And does it, I mean, I think to Commissioner Ashby's point, does it really matter that much?
It doesn't matter at all because the finding is the same no matter what. We don't enumerate the reasons for the finding or the number of incidents that go toward the finding. None of this will come as any surprise to Attorney Beard, who has had several conversations with me about this issue. I guess one conversation, and then there's been some writing back and forth. We have, I want to say always, but I'll go with for at least the past decade, which is as long as I have the institutional knowledge for, treated the 300 days as jurisdictional. So if your day 300 falls on the weekend, you file on Friday. It's always been that way to the best of my knowledge. Like I said, it's been that way for at least 10 years. And that's just, it's because it's in the statute, it says that you must file within 300 days. I can pull up the exact language if you want. We've always treated that as jurisdictional. So if you file on the Monday and day 300 was on Saturday, you are late as far as we're concerned. We especially don't consider it so hard when the complaint itself was timely, because there was an illegal action that occurred, or at least potentially illegal action, that occurred within the 300-day period. Again, the exact incidents don't really count. The reason that Colin dropped the footnote, as I understand it, is to acknowledge that complainant was making the claim in case there's some question about administrative exhaustion. So that's why it's mentioned, because they did certainly plead it, and we considered it as, again, I say we, Colin, I believe, considered it as part of the background, but not as an incident on its own because it was outside of our jurisdiction.
If I can jump in there, I think we need to look at that, Barbara, because I'm also of the view, and I think us trial lawyers are schooled in the fact that the rules are very specific. When the time periods are short, 3 days, 10 days, you don't count the holidays, you don't count the weekends. When they're longer, and I don't know the exact language like 300 days, you count the days, but if they expire on a weekend, it's the next business day. So, but tell me again.
I
tell me-
too am a trial attorney, and again, we don't follow any other rules of civil procedure. They don't apply here.
Okay. All right. Well, that's a legitimate answer. Tell me again why it doesn't matter in the case in terms of what we're considering.
It doesn't matter because the finding would be that Colin made would be reasonable grounds no matter what, because something happened within the 300-day period that Colin found gave rise to reasonable grounds to believe that discrimination occurred. We
don't need that incident.
We don't list out the incidents. It's just a general finding.
Right. Okay. Thank you.
Any other commissioner questions for commission counsel? Seeing none, we've heard from the parties and the investigator. At this time, we'd be looking for a motion. There is one proposed finding. Commissioner David.
I move that we find that there are reasonable grounds to believe that respondent retaliated against the complainant for engaging in WPA protected activity, and conciliation should be attempted.
Second.
Okay, it's been moved and seconded. Any discussion?
I personally am most impressed by what I think goes to the heart of the matter, and those are the complaints about really serious stuff: upcoding, defrauding Medicaid, illegal activities. The refusal to sign that statement, I think, is directly in point, and it also bothers me that they're editing minutes about things that they think are unsavory to have a written record of. And I also agree that clearly the term preliminary investigation is a standard phrase for what the investigator starts. He does a preliminary report and then it goes to the commission. So there's nothing preliminary about this. It's a thorough investigation. That's it.
Any other discussion?
Yeah, I would just second Commissioner David's comments and say that, I was struck by the seriousness of the allegations in this case. And I think that, all things considered, the conflicting accounts of why she was terminated, I think there is an even chance that the complainant will prevail at trial. So.
Any other discussion? Seeing none, the motion is to find reasonable grounds. If you are in agreement, you will vote yes. Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien.
Yes, but does it matter if you can't see me?
Yes, we'll still be in the minutes.
Okay, all right. All right, thanks.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
All right, the findings are reasonable grounds. We appreciate everyone's participation, and the commission will send a letter to the parties and council confirming the results of the hearing. Jeff, could we take 5 minutes?
Okay, let's take 5 minutes. Do we have everybody back?
So,
All right, let's do the next case. That is E22-0023. That's Stephen Fury. I hope I pronounced that correctly. Versus Shaw's. This is a no reasonable grounds case, and we should hear from the complainant or his representative.
Mr. Fury, you're muted.
I'm representing myself this morning, guys.
You have 10 minutes whenever you're ready.
Okay, basically, I worked for Shaw's in Augusta for about 18 months. I started out in the produce section, and I had a little bit of issues with the manager in the produce section, so I got transferred to seafood. Basically, they were understaffing us at the time so drastically. This was during COVID. COVID was going on during this time. They were understaffing us so much that I was forced to leave the seafood deli a lot to back up the deli counter. So I was supposed to be in seafood, and I'd have to leave seafood as the only staff to go work in deli. Sometimes I'd be in the deli department for hours at a time. And I was very concerned about the cleanliness of the seafood case because I have to open the front of the case constantly to get fish out of the case, things like that. So I really should be stationed at the station full time so I can make sure I get all my cleaning done, extra cleaning done to make sure that, everything was safe for the customers walking by, little children touching the glass of the case. So it was critically important to make sure I was stationed there so I could do my job to the highest ability. And because Shaw's was understaffing us, they were trying to save money at our expense. And I was forced to do extra work I wasn't getting paid for, like backing the deli up. That wasn't even my job. I had to do a lot of that. And so I reported Shaw's for the cleanliness issues that I wasn't able to get my job properly done because I was constantly getting pulled out of seafood to work in deli. And I reported everything to the right people. I reported the cleanliness issues, everything. And then right away, it was like the next day. It was like the next day after I reported to Shaw's that I had called the state. They had this big meeting where they told everybody not to help me in seafood anymore. Before that, I was getting help nightly by the deli workers. They were helping me close my seafood section. They get all their work done, and then the woman's name was Martha. She'd come over and she'd help me close. And then right after I reported to the state, Shaw's immediately told Martha, stop helping Steve.
Mr. Fury?
Yes.
I apologize. I forgot to say this at the beginning of the meeting, but please don't use the names of third parties or people who aren't parties to the case. So in this case, anybody other than Shaw's, you should not use their name.
Okay. Basically, guys, I reported to the state, and I was previously getting help from the deli workers before I reported. And then after I reported all the sanitation issues to the state, Shaw's immediately told everyone, stop helping me in seafood. So it was a punishment. They were punishing me for reporting because previously, nights before, Martha was helping me close every night
Mr.
before
Fury,
I reported.
don't
I'm
use
sorry.
her name, please.
Okay. So basically, I was discriminated against. They started cutting my hours, which the record will conclude that. And basically, they weren't accommodating me on anything. I was asking for more hours. They weren't giving it to me. At the end, I was only being scheduled 18 hours a week. I got written up after this, which I hadn't been written up at all. So basically, I was pretty much forced to leave Shaw's because I didn't feel comfortable there anymore. They weren't giving me more than 18 hours a week. They were treating me poorly, being disrespectful to me. I felt like I had to leave. And at the end of it, Shaw's tried to settle my case for $1,100. And I refused the settlement because it wasn't really, for me, it wasn't really about the money, but more the accountability. for Shaw's. So basically, guys, I really feel like I was discriminated against. Shaw's also lied on the record about me disclosing that I had bipolar disorder. I had directly told one of my managers I had bipolar disorder, and she lied about that to you guys, to the Maine Human Rights Commission, saying she didn't know about that. I had sat down with the store manager and told him I had bipolar disorder and PTSD, and I might need a little extra help here and there. And the attitude was, no problem, we can help you out. And then right after, and then not only so multiple supervisors lied to you guys about knowing I had disabilities, about knowing I had bipolar type 1 and PTSD, which I disclosed to both supervisors, thus requiring maybe a little extra help here and there, because my bipolar can be really extreme. So that's why the staff was helping me close. She'd get her work done in Delhi, and then she'd come over and help me. And then, so basically, I was being called over to Delhi constantly to help. So for them to tell Delhi not to help me proves the discrimination, because they were having me go to Delhi constantly to help Delhi. And then after I reported them, they just said, no, you're not going to help Steve anymore. So I was mistreated. I was mistreated as an employee. I was a bipolar individual that had talked to my supervisors, told them I needed a little extra help. They both lied to you guys on the record, on video. They both lied about not knowing about the bipolar, which is a direct lie. I had talked to my store manager in his office about having bipolar, and that's the reason why I might need extra help. And so immediately when I reported to the state, it was like the next day after, which I have a video testimony. One of my people in my case, video testimony, says in a direct quote, it was like the day after I reported. It's in her video testimony. It was like a day after I reported that they went to Martha and said, don't help Steve anymore.
So Fury, I remind you again, please don't use her name.
Okay. So basically, requirements for the whistleblower case was the cleanliness that meets that first criteria. And then second of all, the mistreatment after reporting, that also meets the criteria that my work situation was changed, because formerly I was getting help every night by Martha. She was helping me close the deli.
Mr. Fury, I'm going to stop your testimony if you continue using her name.
Okay. Basically, the employee was helping me before I reported nightly. She was helping me close deli nightly. And then as soon as I reported, I have her testimony. It was like the day after they told her not to help me anymore. And so this was clear as day discrimination, because they were having me go to deli constantly. So why would they be telling Martha not to help me anymore?
Mr. Fury, I'm muting you now.
Okay, that's it.
All right. Any commissioner questions for Mr. Fury? All right, Mr. Fury, you can unmute yourself. Please do not use anybody else's name.
Okay.
Thank you. Just really quickly, Mr. Fury, you referenced a reduction in hours, and I want to tease that out. Before this complaint to the state that you made, how many hours a week were you working?
I was working between 3 and 4 shifts, and basically my hours just started slowly getting reduced.
So how long is a shift?
The shift is about 8, like between 6 and 8 hours, I believe it was.
So you were working 24 to 32 hours a week.
Yeah, basically my point was they were refusing to give me more than the 18 hours. Like I wanted more hours. I wanted better hours, and they just weren't giving them to me, and they weren't giving me a good schedule. You know, I'd ask for things and they'd refuse it.
And that was a change after you made your complaint. Is that what you're saying here today?
I believe that it was a course of mistreatment after I reported. You know, I got written up, which never had happened before. After that,
the investigator made findings. I'm just asking questions specifically with respect to the number of hours that you worked. investigator made findings that you were actually offered shifts that you didn't want. Did that happen after you made your complaint? Do you remember that?
I don't believe so. I don't remember that happening or remember ever stating that myself. I wanted more hours, and they were refusing to give me more than just 3 shifts a week.
Okay,
You know, I wanted better hours, you know, and it just basically my main argument isn't really the hours. It's not really the hours. It's the change in the status of my work situation. Like I said, I mean, before I reported to the state, I was getting help by this employee every night. She was helping me close seafood every night.
Mr. Fury, I believe
Yes.
you've answered Commissioner Ashby's question.
Yeah,
Commissioner
thank you,
Ashby,
Mr. Fury.
thank you. Any other commissioner questions for Mr. Fury? All right, seeing none, Mr. Fury, you'll have about 2.5 minutes when we come back to you. I'll ask you to just mute yourself for now. Attorney Burke, you have 10 minutes.
Thank you. So I just want to highlight a few points in response to Mr. Fury. So first, I just want to point out that at this juncture, you know, the investigator has already heard all of the facts that Mr. Fury is alleging. And so to the extent that this is to provide new information, the only new information Mr. Fury submitted for purposes of today was Shaw's offer to settle this matter for a nuisance value, which obviously is not, you know, an admission that, you know, any wrongdoing occurred, nor should it have been presented. But I just want to point that out, that all of the facts that Mr. Fury just went through were covered in the investigation. And obviously the report makes a number of findings, but again, just for purposes of my 10 minutes, I just want to go through them. So first was that the underlying claim here was solely retaliation under the WPA. So I know Mr. Fury is now, you know, making some other allegations about discrimination, failure to accommodate. But as noted in the investigator's report, those claims aren't at issue. You know, they were addressed, however, in some of the investigation. And so this allegation about the reduction in hours, as noted, you know, Mr. Fury was offered shifts that, you know, he didn't want to take. When this issue of, you know, a potential disability came up, we engaged in a reasonable accommodation discussion. But again, for purposes of today, the sole question is, you know, did Mr. Fury engage in protected activity? You know, let's assume that he did by making a complaint about the seafood department. At the end of the day, he suffered no adverse action as a result of that complaint. If anything, it focused management's attention on the fact that Mr. Fury, who was responsible for cleanliness in the seafood department, was getting help from the deli department to fulfill those responsibilities. And so the entire store was directed, you know, to focus on your own department and make sure you're getting your own duties done before helping others. And so again, that wasn't directed solely to Mr. Fury. It was directed at everybody, as the investigator's report shown. And then to the extent, you know, subsequent to this complaint, Mr. Fury no longer works for us, but again, he voluntarily resigned. So again, I just want to point out that there is no basis to find an adverse action here. So I'm going to leave it at that unless people have questions.
Any commissioner questions for Attorney Burke? Seeing none, Attorney Burke, you'll have about 7.5 minutes when we come back to you. Mr. Fury, you have 2.5 minutes left if there's anything else you'd like to add. Just, you're muted. Mr. Fury, you're muted right now.
I'd like to thank all you guys for your time in this case and looking at my case. And, you know, I was hoping to create some change from this whole thing. Like, for example, places like Shaw's stop understaffing us so we can actually do our jobs, so we can actually clean properly. You know, I was getting constantly sucked into the deli department, which I wasn't even being paid to do. And so seafood cleanliness was going by the wayside. Because I was in deli so much, that's why the deli workers were helping me close at the end of the night, because I'd spend 3-4 hours in deli. I mean, you could check the cameras, you can check the records, see I'm in and helping the staff in deli 3-4 hours at a time. Nobody's in seafood at that time. Nobody's cleaning. Nobody's cleaning the windows. Little kids are walking by, touching the glass windows. Nobody's cleaning it. And like I said, before this happened, Martha was helping me close every
Mr.
night.
Fury,
Yes.
please do not use, I have reminded you repeatedly,
Yeah.
if you cannot refrain
The
from
staff
using. her name, I will end your time.
the staff person was helping me close before I reported. After I reported to the state about the health and safety issues, Shaw's directed that staff person to no longer help me close anymore. So they changed my work situation, which they were slightly accommodating my bipolar by letting staff help me, because letting Martha help me close because I was helping her 3-4 hours in.
Mr. Fury, I have now muted you because you have repeatedly used that staff person's name. So I'm ending your time right now. Third-party names are confidential under our statute. You may not use them at a public hearing. Any further commissioner questions for Mr. Fury? All right, seeing none. Attorney Burke, you have about 7.5 minutes if there's anything else you'd like to add.
No, again, Mr. Fury's not raising any new facts that were not investigated in the original charge. So unless anybody has questions, I don't think there's anything to add.
Commissioner questions for Attorney Burke? Right, seeing none, we've heard from Mr. Fury, we've heard from Attorney Burke. We'll next hear from Investigator O'Reilly.
Good morning, Commissioners. I'm Investigator O'Reilly. I wrote the report on this case. It was part of the investigation was conducted by a prior investigator, but I completed the investigation, reviewed the entire record, and wrote the report in this matter. I don't have much to add. I agree that everything that's been presented today is information I have heard before, information that is in the record. The finding was that there was no adverse action despite Mr. Fury's contention today and his contention throughout the investigation, asking employees to focus on their own areas so that their own areas don't suffer because they're helping employees in other areas is not an adverse action. And any other actions that were alleged, including the hours or any other issues of sort of disrespectful treatment, were not substantiated in terms of being denied anything in employment. I also want to clarify the issues of disability were not brought up as part of the initial complaint, got mentioned as part of the issues and resolutions conference in this case, and there was some discussion that the investigator was copied on by Mr. Fury, sort of ongoing as he began a discussion with his employer regarding possible accommodations, but that was not a claim that was made in this case. Accommodations were not a part of the allegations. There is no disability issue. And I will state that Mr. Fury's contention today that Deli was helping him, Deli employees were helping him because of a disability, that is not in the record. That allegation was not made. He did say that Deli employees were helping him, but he did not say that that was something that was being done because of a disability. He's never alleged that his disability affected his ability to do his job. So that was not the issue that was presented in the case. I am happy to answer any questions.
Thanks, Jane. Any commissioner questions for Investigator O'Reilly? Commissioner David.
Good morning, Jane. Do I understand that it doesn't matter in your conclusion that whether or not he made a written report, which I don't think we see, or that you focus on except to mention it, it doesn't matter because there's no adverse action. I think I understand that, and I'm impressed with that argument.
Correct. And the issue with a report under the Whistleblowers Protection Act is that it doesn't have to be written, and B, it doesn't have to be correct. An employee just has to have a reasonable belief that what they're reporting. So respondent provided the inspection report that said that there was no sanitation issue in the seafood department, that there was no actual issue, but it was credible that Mr. Fury believed that he was not able to clean up to the appropriate standards. So his report was a reasonable belief that he had, that there was something that was risking the health and safety, even if he inevitably was incorrect. So the report did find that he engaged in protected activity, even though there was no adverse action.
And what was he written up for as an employment discipline?
So I actually, thank you for bringing that up. I'd forgotten about that. I do not believe there are write-ups in the record. My recollection, I was looking back in the final submission submitted by complainant, and they mentioned the issues with the hours, but I do not believe there's any discipline submitted as part of the record as an adverse action. So that's new information to me.
Oh, sorry, Commissioner David, were you raising your hand or were saying you're all set? Okay, great. Any other commissioner questions for Jane? Okay, Seeing none, thank you, Jane. We've heard from the parties and the investigator. At this time, we'd be looking for a motion. There is one proposed finding. Don't everybody talk all at once.
I'll move that we find that there are no reasonable grounds to believe that the respondent retaliated in violation of WPA and the complaint should be dismissed.
Second.
Okay. It's been moved and seconded. Is there any discussion?
No, I mean, I think it's correct that there's no adverse action here.
Any further discussion? Seeing none, the motion is to find no reasonable grounds. If you're in agreement, you will vote yes. Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien. You're muted, Julie.
You can't hear me or see me. Yes.
Oh, Julie, I did, but I didn't hear your vote.
Yes.
Great. All right, Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Right. The findings are no reasonable grounds. We appreciate everyone's participation, and the commission will send a letter to the parties and council confirming the results of the hearing.
All right, the next case on our agenda is E22-0086. That's Scarborough versus Callan. That is a no reasonable grounds case, and so we should hear from the complainant or his representative.
I don't think that complainant is here. Investigator Beauchesne, do you see anybody you recognize as complainant?
No, I do not.
I'm just gonna go make sure there isn't anybody outside waiting. I'll be right back.
What, could I ask a question of Barbara before we get into this?
Sure.
Why San Antonio, Texas and Suffield, Connecticut, why do we have this case?
Because that is where complainant now lives and where the company is based, but the work that was done was occurring here in Maine.
All right, thank you.
Welcome.
All right, I do not see Mr. Scarborough. I have not received any messages from him saying he can't get in. Right. So in this case, since the complainant is not here, we would default to the investigator's report, which was, these ones always throw me. All right, so there are two proposed findings in this case. No reasonable grounds to believe that respondent discriminated against Mr. Scarborough, and no reasonable grounds to believe that respondent subjected him to retaliation for engaging in protected activity. Do I have a motion?
Yeah, I'll move to adopt the findings of the investigator that there are no reasonable grounds to believe that the respondent discriminated against the complainant on the basis of race and or color, and no reasonable grounds to believe that respondent subjected the complainant to retaliation for engaging in Act or WPA protected activity, and the charge should be dismissed in keeping with the Act.
Do I have a second?
Second.
Any discussion? Seeing none, the motion is to find no reasonable grounds on both recommendations. If you're in agreement, you will vote yes. Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes. Commissioner
Walker.
Yes.
Okay, the findings are no reasonable grounds on both counts. Melena, I believe you're here for respondent, is that correct?
That's correct. Good morning.
Okay, great. We will send a letter to the parties and council confirming the results of the hearing. Thank you for being here briefly, and thank you, Investigator Brochane, for being here as well.
Thank you.
All right, well, then we're left with MHRC number H23-0278, A and B. That's Susan Susi versus Erica Frisbee and Kevin Frisbee. This is a no reasonable grounds case, and we should hear from the complainant or her representative.
I actually don't believe that anybody is here for this case. I did hear from respondents many times over the last couple of days saying that they did not believe there was any need for this case to be heard. But I also don't see complainant here. Investigator Brindley, do you see anybody here you recognize as complainant?
Not.
Okay, and I just checked, there's nobody in any of the waiting areas here, and I haven't heard from Ms. Susie at all. So again, this is a no reasonable grounds case. Since the complainant isn't here, we would default to the investigator's report. There's one finding there. Do I have a motion?
I'd make a motion that we accept the report that there are no reasonable grounds to believe that discrimination occurred. And I can't find the wording.
Okay,
and it should be dismissed, and it should be dismissed.
Second.
Sorry, who was that? Jeff? Okay. All right, it's been moved and seconded. Any discussion? Seeing none.
Well,
yeah.
I mean, I was troubled by this case. I'm disappointed that it's not going to be fully argued. As I understand it, the footnote 4 by Alex indicates that she's basing this on the fact that there's a protection from harassment, and that our finding might conflict with that. And I don't think that that's our business, and I don't think it would. I mean, there are the law is not a jerk. I mean, the law has ways to deal with if that's the basis of saying that there's a recommendation for no reasonable grounds. I should have asked this to Alex when you said it. I'm not sure if you asked if there were any questions of her. Could I do that? Could I ask Alex that?
Sure. I think that's fine. Just add Alex's pronouns are they. But yeah, you can go ahead and ask them a question if you have one.
Yes, Alex, is that correct that you found it significant that there was a protection from harassment existing between the parties as a basis for the commission, as a basis for your recommendation that we find that there's no reasonable grounds because that might cause a conflict with that order?
Correct. So in my report, you'll notice that there are two exhibits, A and B. They both show the parking lot of the premises, and as you can tell, that there are very few parking spaces. So with the protection from harassment order between complainant and her neighbor, it would essentially be impossible to accommodate complainant's request, because then she would have to communicate with her neighbor who has the protection order against her in order to, have these cars to move them or in any way. She would either have to give up the garage so that she can park in front of her door and have the car spot behind that car, or she would have to interact with her neighbor in order to get out, or have her neighbor contact her in order to move cars. That certainly wouldn't be possible because complainant, number one, didn't want to give up the garage. And two, the protection order, prohibits communication between the complainant and the neighbor.
And you say in your footnote 4 that if the neighbor didn't have a protection order, essentially you would find your recommendation would be that there are reasonable grounds.
Certainly. If there wasn't a protection order between the parties that said no communication was to be had between them, it would be essentially no problem to facilitate, changing parking spots.
You've answered my question. I have great reservations about the legal significance of that. Thank you.
We have a motion open to find no reasonable grounds. Any other discussion about this case?
Well, I'm going to vote against the motion. Deal with our job is to find whether there's reasonable grounds to believe that there was discrimination. If somebody has to deal with the protection from harassment case by vacating it under Rule 60 or modifying it or whatever, then do what you need to do. But
Any further discussion?
Well, first of all, I like that statement. The law is not a jerk. That's first of all, the law can be a real jerk.
There's a stronger word there from my law professor.
I like that precept though. Am I correct to understand? Maybe this is still another question for Alex. Am I correct to understand that the neighbor, even if allowed to park next to their door, the complainant, even if allowed to park next to their door, also wanted the space in front of the garage because they wanted access to their stuff in the garage? Because that seems to be quite unreasonable.
That's correct. So from what I understood from the complainant, she wanted to keep her garage, but she also wanted to park in front of her building and leave the spot behind the garage open for her visitors, and so that she could access the storage, the stuff that she stored in the garage. So essentially 3 parking spots.
And was that the bottom line? Was that the last offer made by the complainant, or the last request for accommodation made by the complainant? Or did that morph into an understanding that, no, I couldn't possibly keep all those parking spaces. I just need the one next to my door?
No, she wanted all 3.
Okay. Well, in this case, maybe the law's not being a jerk, but maybe somebody else is. I'm just kidding. But that seems unreasonable, right? I mean, I guess that's where I would land. Otherwise, I like Ed's argument. I had a little bit of unease about this as well. I'm interested, Ed, in what you think about that.
What I think about what? Yeah, I mean, I think she's being unreasonable in those demands, and I think there's reasonable grounds to believe that there's discrimination.
Am I okay? But am I missing something? If the complainant is being unreasonable in her request, then it's not a denial of reasonable accommodation to say no, right?
Oh, I'm sorry. You're saying that the complainant's demanding that a space be left empty. I'm not sure that I fully understood the diagram.
You need assistance with the diagram, I can certainly explain it. It's not the best drawn, but I provided it from the respondent. So if you look at the picture, the little rectangle bit with the garage hanging out, that's the building. So the garage is this little bit on the left that's sticking out. So it has 1 car and then 1 car behind it. And then the next 4 tiny squares, or the next 3 in the row of 4, are also parking spots, with 3 additional parking spots behind it with the arrow pointing up. So those are the available parking spots at the premises. The garage and behind the garage, and then the 3 in front of the building, and then the 3 behind those spots.
And so what is it that complainant wanted?
Complainant wanted to keep the garage, and she wanted to park next to the garage in front of her door, but she also wanted to maintain access to the garage so that no one would be able to park behind the garage.
In where it says second floor?
Yeah, she wanted the 2 that are in the column labeled Sue, so the garage and the one behind it, as well as the one closest to the building in the column that says second floor.
Thank you, Barbara.
Well, I'm not sure that I can adequately answer your challenge, Jeff. I wish, that's why I wish there'd been a fuller explanation by complainant. It just seems to me that there ought to be a way to work out the parking spaces. And I insist on ignoring the protection from harassment. That's why judges hate those cases anyway.
Further discussion?
Yes.
Okay.
I know I made the motion, but I'm a little bit intrigued by this. Assuming, and I think this is for Alex, assuming that, well, first of all, I don't know if it was mentioned, I assume it's in the record, how long the protection from abuse order had been in place, and how long was it for? And well, let me just leave it at that. Do you know that?
Sorry, I was unmuted. So I know for a fact that the complainant made 2 requests for reasonable accommodation. The first was untimely. And before complainant made her second request for accommodation, the neighbor had filed a protection from harassment against her.
Oh,
Julie, I'm looking on page 2 of the report, just above legal analysis. There's a 1-sentence line that says, on June 23rd, 2023, neighbor received a protection from harassment order against complainant.
okay. Yep. Thank you.
And then it looks like the second reasonable accommodation request was sometime in August or September of 2023. Alex, is that right?
That's correct.
All right. Thanks.
Any further discussion? All right, seeing none, motion is to find no reasonable grounds. If you're in agreement, you will vote yes. Commissioner Ashby.
Yes.
Commissioner David.
No.
Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
All right, Commissioner Walker.
Yes.
Great. The findings are no reasonable grounds. Thank you, Alex, for being here. Don't spit out your water. The commission will send a letter to the parties confirming the results of the hearing. All right.
Pursuant to 1 MRS section 405(6)E, I move to go into executive session to consult with our attorney regarding pending and contemplated litigation and the legal rights and duties of the commission.
A second?
Second.
It's been moved and seconded. Any discussion? None. If you vote yes, you're in agreement. Commissioner Ashley.
Yes.
Commissioner David.
Yes, and review what we're going to have to do. We're going to have to click on an invitation. Is that right?
Yeah, I'm gonna set up a breakout room. It might take me a few minutes. Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
All right, Commissioner Walker.
Yes.
Great. Okay.
Okay, I think I'll move to adjourn.
Second.
I don't think we need a motion.
Okay, then goodbye. Be well, everybody. Merry Christmas. Happy holidays.
Happy holidays, everyone.
Happy holiday.
Bye.